Welcome to all you amazing people. Today, a truly historic judgment has come from the Honorable Supreme Court. A judgment against all odds. A judgment which has overturned two previous Supreme Court judgments in effect. It has done that. A judgment which concerns one particular issue, but the impact of that judgment will be felt in many other issues. In fact, the battle was so difficult that in winning this battle, Sanatan Dharma, as I say, has showed again why it is the oldest continuous living civilization. So many civilizations came, flourished, and they have disappeared into the mists of time. Sanatan Dharma survives against all odds because it keeps fighting in a legal, peaceful manner. It just refuses to give up. This is concerning a huge ecosystem which has problems, and I have no qualms in saying, which has problems with Hindu festivals, Hindu heritage, Hindu tradition, and so many aspects of Hindu religion that you could almost say they have a problem with anything and everything a Hindu does in his life. This ecosystem is also quite shameless. On the same issue, they will close their eyes if it suits their interest. But if it somehow stops, restricts Hindu rights, they will have no qualms about going to any length to stop it. Now, I am talking about a judgment by the Constitution Bench today, a judgment which is of seminal importance. The judgment is on an issue of Jallikattu, a more than 3,500-year-old tradition, culture of not only Tamil Nadu, but also various parts of this country, Maharashtra, Karnataka, with different names. So from 1990s, some people wanted to stop this. Because why should a celebration, a peaceful celebration, be allowed? But Tamil Nadu government, because the people were one-sided, so irrespective of the political party, the government of Tamil Nadu understood it also. And the people made the government understand, which is how democracy should function. So a law was passed in 2009, which effectively allowed it because the various interests from 1990s were trying to stop it. But then, in center was a different government, a UPA government. What they did is they made a slight amendment. It seems very small amendment. It seems a very small change, but it had a very large, a very deep impact. The change was that they brought bulls into a list of animals whose training and exhibition is prohibited. Then in 2014, the Supreme Court banned Jallikattu in Tamil Nadu and neighboring states. 2015, Tamil Nadu government approached Supreme Court seeking effectively a review. That was dismissed. So effectively, Jallikattu, a 3,500-year-old tradition, would have effectively been banned. And it won't have stopped there. You have seen the propaganda done by certain vested interests on Diwali, on Holi, on Raksha Bandhan, on Karwa Chauth. The reasons could change. Holi would lead to eve teasing. Raksha Bandhan is a way of promoting patriarchal interests in the society. Diwali is obviously pollution. So reasons, dahi handi is dangerous because it's so high. So reasons would change. The effect, because once you stop the celebration, once you stop festivals, slowly, the way of life will end. You know, Hindutva has been described as a way of life. So if you can, by salami slicing, keep reducing, keep changing, keep restricting the way of life, you achieve your aims. Anyways, so 15, the judgment, the review was not allowed. One would have thought the topic is over, but the topic did not get over because of the incredible people of Tamil Nadu. Large scale peaceful protests were done. And the central government changed two things. And a notification was brought in by the NDA government where an exception was carved out for Jallikattu and bullock carts, races. Why was the exception carved out? You will ask me. And why do I say the hypocrisy of a lobby which was talking about animal rights? If you talk about animal rights, why don't you talk about slaughter of animals? Especially slaughter done as a part of various religious rituals where you will not speak a word. Also, there are various types of slaughter. For humans, for example, I will tell you, US has death penalty. It gives it way more frequently than, for example, India. But while they give death penalty, there has been a long debate on how should the death penalty be carried out. Because it should be carried out in the least painful manner for even humans. But, and there are, death can be there, but there are manners or means by which death could be painful and in which it could be relatively painless. So there are also ways of slaughter which could be painful and which could be relatively painless. But Prevention of Cruelty to Animals Act, Section 28, has a clear exception, that if the killing is being done as per any religious rites, traditions, etc., etc., I'll put the exact words out, you can check it out, Section 28, then it is not covered under the scope of the Act. Do you see the beauty of that? And clear exception is carved out. But a race, that is very dangerous. That is somehow very violative of animal rights. Anyways, be that as it may be, the central government brought a notification. The Tamil Nadu Assembly passed a law which was supported by most parties, both the leading parties there were supported by it. And then, because the law was passed, certain people challenged this before the Supreme Court. The challenge went to a division bench which said no. Now this involves substantial questions relating to the interpretation of Constitution. 5 such questions were framed broadly. Is it a culpable legislation? Can the Tamil Nadu government do this? Is it covered under the cultural heritage of the people? Article 29. In pith and substance, does this ensure the survival of the breed? Whether it is violative of Article 51A G, 51A H, whether it is violative of Article 1421, and lastly, whether it is violative and it is contrary to judgment in A Nagaraja case and the review judgment which had basically banned Jallikattu. Strenuous arguments, Animal Welfare Board, PETA, Federation of Indian Protection Organizations, various NGOs, etc. As I told you, the aim has always been either using courts by approaching them on various parameters, keep approaching them, or in society, what I call the soft power. Use your soft power to somehow make it, oh, Diwali is pollution. Data shows, science shows that it has negligible, insignificant effect on pollution. No, that won't suit. And data and science shows from 4th July US to New Year's Eve how the entire world will burst crackers. But Diwali, you should not. And Holi is, of course, an open license for Eve teasing, so that has to be banned and that has to be regulated. They can't ban it. So they start a campaign against colors. They start a campaign against, oh, it is dangerous for women. And so many influencers on Holi will wish you by giving you a lecture on how you should celebrate it. Wish you Diwali giving you a lecture. But for other festivals, it will only be pure good-hearted wish. Anyways, that's not the court's problem. That is a problem which you, me, have to fight on awareness level amongst the people. In court, the court, by a constitution bench, gave what I said a historic judgment, because this will now preserve the cultural heritage rights. Because the earlier judgment had also said that no, it's not a cultural practice. See, if you say it's not a cultural practice, see, words are important, definitions are important in law. If it is not a cultural practice, if it is not a religious practice, if it is not a practice covered under the Constitution, your fundamental rights, then there is no protection. So the Constitution bench said 5 things. First, cultural heritage borne out by tests and evidences, the court will not intervene into the matter. The court will not disrupt the view of the legislature because it is best suited to know what is a cultural practice. This will have effect in so many other cases where, because what is a cultural practice, no NGO or vested interests will be able to get it banned or blocked or regulated if your government, whichever government you choose, in whichever state you choose, wants to identify it as a cultural practice. It will really help in those cases. Second, the court said Jallikattu cannot be termed as a blood sport because nobody is using any weapon and blood is only incidental to the thing. Nobody is wanting to kill the animal. It said there is no colorable legislation. It is well within the competence of the state to do it. The president has also assented to it. Also, it said the view that it is not a part of cultural heritage in the earlier judgment is not a view they will agree with. So, effectively, against all odds, the laws made by the state of Tamil Nadu, by the center, the practice of Jallikattu, and in Maharashtra and Karnataka, it will continue. The challenges are immense, but this shows that if you do not give up, if you keep striving, keep fighting, from 90s an attempt was made, 2014 that attempt succeeded, 2016 it had succeeded, but finally it has flopped miserably. And one last thing I would tell you, all festivals of Bharat, you must celebrate rigorously and religiously. Because if you don't celebrate it, please remember there are enough vested interests which want to regulate it into extinction. That is important. Anyways, a very good day and a very good victory for Sanatan Dharma. Bharat Mata ki Jai.